It's actually quite refreshing to be getting into the swing of these videos and moving on to a new unrelated topic now that we've covered actus reus and mens rea, which ironically I'm sure could be viewed something like art and part co-accused to each other in some terrible legal humour. Disclaimer: this video is intended for academic and entertainment purposes. Nothing within this video constitutes legal advice. I'm not a lawyer. I am a recent LLB and diploma graduate, and this video is intended to help other students on their journey. I may be wrong on any and all of these points, but I have tried to be as faithful as possible to my original lecture notes and to my own understanding of Scots law as a successful student. Case citations will be in the description. So as we've now covered and hopefully understood, the general principle is that an accused person can only be held liable for their own voluntary criminal acts, or indeed their own criminal omissions, when they are committed, well, voluntarily, recklessly, or negligently, subject to possessing the required mental state for the offence, of course. In general, it would be grossly unjust for anyone to be held liable for the acts of someone else. After all, even people close to us are living their own independent lives, with their own independent decision-making process. We may be involved in that, but we cannot make good law-abiding decisions for everyone. Even if we did, how would we enforce that? Parents of underage children aside, we have no option to simply lock someone at home so they cannot go out and shoplift. That would, in and of itself, be a criminal act. We must let other people get on with their mistakes. Art and part liability represents a departure from this rule under certain circumstances. The broad idea is if a group of individuals act in concert in some way to commit an offence, they are liable for the offence as a whole, rather than the possibly minute role they actually played in the commission. Each person involved with the offence is held thereafter jointly and equally liable, even if only one person performs the actus reus. The principle of art and part liability applies to both offences known at common law and to statutory offences, as per section 293(1) of the Criminal Procedure Scotland Act 1995. It states that a person may be convicted of and punished for a contravention of any enactment, notwithstanding that he was guilty of such contravention as art and part only. The subsection itself uses the terms aiding and abetting as well as art and part, which may be a more familiar term to some, and is dealt with further in section 293(2). The subsection states that, without prejudice to subsection 1, above or to any express provision in any enactment having the like effect to this subsection, any person who aids, abets, counsels, procures, or incites any other person to commit an offence against the provisions of any enactment shall be guilty of an offence, and shall be liable on conviction, unless the enactment otherwise requires, to the same punishment as might be imposed on conviction of the first mentioned offence. I only go to the bother of reading those sections, by the way, because I often know that, especially for first years, you'll be handed an act in a section and given its general gist but not its precise wording. I find that's unhelpful personally, and probably just starts a bad habit of not checking your sources. Know what it is that's in the sections you're quoting. They're all available for free on the government's website, so it's not even like you have to spend £50 on a textbook you'll never actually read, as I admit I have often done. Back to art and part liability. From an accused point of view, the concept no doubt seems very unfair. Certainly I'm sure there are many unhappy defence teams out there who have had their ears torn off trying to explain how it works, because it does, in many ways, go against the idea of justice, and that being punished for a worse crime than the one actually committed seems counterintuitive to fairness. After all, if you're a small-time criminal whose only part in the commission of a theft is keeping a watch for any police, it's quite understandable that you'd argue you yourself haven't done anything illegal. Standing on the side of the road, observing cars and people that pass isn't ordinarily a crime. It's a very boring hobby, but people watching is something many people do to pass the time. This perceived unfairness is justified mostly by public policy reasons. What acts the accused has actually physically taken part in may be legal, but they have knowingly facilitated a larger crime. That larger crime may not have been possible without that accused's input even if it is only a small input, if that offence is of a complex nature. For example, though it rarely happens, you might wish to imagine an elaborate bank robbery that would not be possible without the getaway driver. See HM Advocate against Lappen, 1956, per Lord Patrick at paragraph 110. He gives quite an in-depth description of such a convoluted theft wherein he says, if a number of men form a common plan whereby some are to commit the actual seizure of the property, and some according to the plan are to keep watch, and some according to the plan are to help carry away the loot, and some according to the plan are to help dispose of the loot, then, although the actual robbery may have only been committed by one or two of them, everyone is guilty of the robbery because they joined together in common plan to commit their robbery. Lord Patrick goes on further and he clarifies with a caveat to the doctrine. Such responsibility only arises if it has been proved affirmatively beyond reasonable doubt that there was such a common plan, and that the accused were parties to that common plan. If it has not been proved that there was such a common plan, or if it has not been proved that the accused were parties to this previously conceived common plan, then in law each is only responsible for what he himself did, and bears no responsibility whatever for what any of the other accused or any other person actually did. There are further limits to art and part liability, described by Lord E.C. and McDonald against HMA 2006 at paragraph 20. Where two or more people embark upon a common criminal purpose, they are normally responsible for what happens in the course of the execution of that purpose. It is the unexpected and unforeseen going clearly out with the parameters of the joint purpose, for which art and part responsibility is elided. This is a little bit related to the idea of causation we touched upon with mens rea. The chain of causation and therefore liability is broken once events turn from the path of foreseeable consequence, be that by an act of God or an act of a third party. You cannot be held art and part liable if you will, in the commission of a housebreaking with a second individual, come across the scene of a murder. That much more serious offence is clearly completely unrelated to the housebreaking being done by you and your co-accused. I couldn't name any cases off the top of my head, but I can anecdotally think of some news stories where individuals have come across worse crimes while in the commission of some kind of theft, usually housebreaking, and then they report the more serious offence to the authorities. I would personally love to hear the 999 call with the burglar trying to explain that to the call handler. Art and part liability comes in three different flavours: joint commission, innocent agency, or associate liability. Joint commission occurs where two or more accused perform acts together that constitute an actus reus. They are said to be acting in concert, which is a phrase I've already used, I think, though I'm going to take a moment to clarify it slightly, and that to be acting in concert may infer the existence of a pre-planned commission between parties in the sense of a premeditated plan, but it may also be what are called spontaneous actings. Two co-accused do not need to have discussed an assault at an earlier time to be art and part liable if they, both working together, attack the same person. Plans can be formed at the time of an offence. The difference plays a significant role in homicide cases, as the difference between pre-planning a murder and a death occurring unexpectedly in the commission of a crime is often where the line between murder and the lesser sentence of culpable homicide is drawn. Joint commission can be problematic in cases where the original offence, usually assault but also sometimes housebreaking or other types of theft, lead to a death. This is particularly true if a number of co-accused have attacked or could have possibly attacked the victim. Even direct eyewitnesses can be left without any idea who pulled the knife that led to a victim's death in a mob of punching and kicking, but equally so can the co-accused be just as surprised. Take for instance Boyne against HM Advocate, 1980, where a group of three co-accused had been partaking in an ongoing series of robberies. Unexpectedly, one of the three had produced a knife. The carrier of the knife explained it had been brought for protection and he hadn't actually intended to use it. His co-accused were able to avoid charges for the stabbing, as their art and part liability ended when the actions went unforeseeably out with the scope of their concert. Contrast this to Mathieson and Murray against HM Advocate in 1996, where a knife was pulled but the co-accused continued their attack on the victim. The court took the view that the co-accused had accepted this use of the knife and therefore were liable, even though the knife hadn't formed part of their original plan. If death occurs but the Crown cannot prove that the accused were working in joint commission, or alternatively who struck the fatal blow depending on the circumstances, then all of the accused must be acquitted. They may still be charged with assault, but that must be really cold comfort to the victim. See, for example, HM Advocate against Welsh and McLachlan in 1897. I appreciate that as an old case, wherein two men broke into a house and killed the occupant. As it was not known which of them had done so, and there was no evidence that the murder or violence in general had been part of the joint commission, both had to be acquitted. The second type of art and part liability is innocent agency. This, I would imagine, is by far the least common of the three. Innocent agency describes a situation where person A uses person B to commit the actus reus of a crime, but B lacks the mens rea in order to commit that crime, be that because they lack some vital context or because they have a defence such as coercion. I won't describe the next case in too great a detail. Citation can be found in the description as always if you would like a more in-depth read, but it involves the offence of rape, and since this is not a video explicitly about sexual offences, I don't wish to presume to impart more than I must to make the necessary point about art and part liability. In R against Cogan and Leak, 1976, we have a situation where Leak, one of the named accused, forced his wife to have sexual intercourse with a friend, the other accused, Cogan. Cogan was acquitted of the offence as it was established that he had a genuine belief that the woman had consented. Leak, however, was convicted of aiding and abetting rape as he knew she had not. Leak appealed this decision, but the appeal was dismissed. Cogan was an innocent agent, and it was irrelevant that he had been acquitted since Leak himself had both procured the actus reus of sexual intercourse without consent and had the mens rea of knowing his wife had not consented. That he had done so through an unknowing third party made him no less liable. The final type of art and part is associate liability. Associate liability occurs where the accused is art and part guilty because of the actus reus of another. Associate liability can be thought of as innocent agency, except all parties are aware of the crime. It differs from joint commission because parties do not need to work in concert, which would imply all co-accused are taking part in the actus. Instead, a singular person may physically commit the offence while the others are simply involved with the planning. Associate liability is also very problematic, I would suggest, and it's the one I've spent the longest on within the script, trying to get straight as it is easily understood. Honestly, I'm not sure I entirely understand it myself, so how any first years are meant to, I'm not quite sure, but that might just be the result of my notes being several years old and possibly quite bad. Though I may have just said the words liability to the extent it no longer sounds like a word. In short, though, only one person may physically go and obtain the documents in order to commit a fraud, though they may have several others advising them on how to go about this. Each of these people are art and part to the fraud. An associate can be convicted of art and part involvement even where the person performing the actus reus is acquitted. For example, the primary accused may have a defence such as mental disorder that applies only to themselves, while their co-accused are left to face the full charge alone despite possibly doing very little. The case my lecture notes have written down as an example of associate liability in this way is Capuano against HM Advocate, 1985. But I'll admit to not understanding why the lecturer pointed us in that direction, as the case relates to an alleged assault committed by three accused. An offence that, to me, sounds like it should be joint commission art and part and not associate. Only one of the three accused was convicted, so it does demonstrate a similar principle, but weakened by the fact this accused had participated in the actus reus. I take this to mean that the case law in this area is quite weak, and there's not a lot to go on for demonstration, which also means it's not well tested in court. I can't actually find any better or more straightforward cases on this matter either, so perhaps my confusion represents where the law itself is with it. But my notes point me to Melvin against HM Advocate in 1984, and McKinnon against HM Advocate 2003 by way of explanation as to why only a single accused may be convicted while the others may be acquitted. The first of those cases involves Art and Part accused being convicted of different but related offences, murder versus culpable homicide, because of so-called striking differences in their conduct while working in common purpose. The second case takes a further, more developed view, and stating that it's too simplistic to view participation in an assault which caused death in the course of a robbery as enough to amount to murder. The court must consider all evidence against each accused. As with many things in criminal law, the court is often entitled to take a view of the facts as they see fit. Particularly where there's no statute and no precedent, what we assume the law is, at least to me, is essentially worthless without testing. Novel cases are a little dangerous for everyone involved because they're really anyone's game, and a bad precedent could definitely have a devastating knock-on effect down the road. Though, and it is more depth legal theory here, you're not really supposed to make decisions based on a sort of floodgate effect, but then some judges certainly do think about that sort of thing. So it's beyond my pay grade, basically, to talk about. The law in this area, despite the fact I've cited possibly triple the amount of cases as I did in my last video, potentially isn't as fixed at certain points as I think even I imagined it to be before writing this video. I'd be interested to hear from any academics who've done work in this area, or even solicitors with experience handling similar art and part cases, to see what they think. Ask your lecturers, maybe they know. The last point I have to touch upon is whether or not withdrawing from the Commission absolves liability. Generally, the answer is no, unless the actus has not yet been put into effect. If a crime is merely in contemplation or is still in a state of preparation, then a perpetrator can leave without later being found jointly liable in most instances. As we've previously discussed, thinking about a crime is not itself a crime, though it does get more murky after the engagement of multiple persons. Still, the accused may leave the enterprise and absolve himself, so says Lord Justice General Elmsley more or less in his judgment of MacNeil against HM Advocate in 1986. However, after the criminal acts have actually begun, withdrawal is no longer an option. An accused who leaves midway through an assault will still be held liable for an assault. Lord Elmsley does, however, suggest that perhaps if an accused takes proactive steps in stopping the continuation or the completion of an offence, they may be able to escape liability. For example, if A and B commit an assault on C, and during this assault A produces a knife, B may intervene. B has presumably not agreed to commit murder, and if they immediately phone an ambulance and begin rendering first aid to person C, it's very unlikely that a court would find B art and part liable for attempted murder, because B's conduct showed they tried to assist C. B's conduct may very well be the reason person C survives that attack. B still may be charged with the assault, but no more than that. This is also very law in theory, and a more up-to-date judgment on a more solid set of facts may completely overturn this. But I like it in principle because it allows an offender to walk back their offences at a point they no longer feel comfortable. There is no additional pressure put on them by the law to escalate the situation. If they will automatically art and part to murder, if a co-accused unexpectedly pulls a weapon, it presents pressure to just go along with it and do harm to the victim. Perhaps then go further and cover up the offence, hide the body, dispose of evidence. Because they're facing a life sentence anyway, they might as well try and get away with it. If what Lord Elmsley says is to be taken as the correct position of law, it presents incentive to stop and aid the victim instead. An accused is unlikely to do any custodial time at all for a first offence of assault, especially if there are other mitigating factors or considerations for the court. In this way, a victim too might go off with painful injuries, but injuries they will survive. Maybe that's thinking too optimistically of the average accused understanding of legal precedent, but I prefer it to the alternative. This brings me to the end of the video. I took a bit longer with this one, partly due to being busy and partly because I went off on a Westlaw tangent with some of these cases. This one I expect is going to be the longest I've done yet, so I'm thinking I might go for something I anticipate being shorter and easier to explain next. Though I did think this would be quite easy before I started writing this. Possibly the criminal standard of proof and what that actually means will be up next, so if that's of any interest to you, feel free to subscribe and I'll see you next time.